Recording. And yep, so we're going on. We have 17 of you joining us, either by video or one intrepid soul is on a phone. So we'll do the best we can to keep it interesting. As I mentioned before everyone got on the call, we're going to do some polls and questions throughout the webinar. And before we get into that, my name is Rich Shapiro. My partner in crime here is Megan Conroy, and we're going to teach you all a little bit about the world, the mysterious and wonderful world of Medicaid and long-term care planning. So, of course, our webinar title is Everything You Wanted to Know About Medicaid but Didn't Know Who to Ask. Well, I think we're the people you can ask. There are other people, but we are two of the people in the area who can answer your questions and guide you through this sometimes convoluted and torturous process. Before we do that, I'm going to start with a poll. It's always fun to get you going. And as I mentioned earlier, there is everyone is answering anonymously. So whatever answer you wish to give, please do and try to participate. It's more fun that way. So I'm going to launch the first poll. So our first poll is, what is the biggest challenge facing seniors in 2020? Obviously, there's no one right answer because this is your opinion. So if you could throw in your vote here, we have estate taxes, outliving your money, preserving assets from the expense of long-term care, and providing inheritance for your children. Okay, so far only two of the categories. Oh, we've got a race here between questions 2 and 3. We'll do another 20 seconds. We almost got everyone voting here. And we got, most of us have answered. We'll do another 10 seconds to let everyone participate. We're almost in a dead heat here. Okay, we're going to end the polling now. So 10 of you said outliving your money, or maybe not your personal money, but the generic seniors. And the other 9 of you said preserving assets from the expense of long-term care. Probably number 20 is the person on the phone who couldn't read the poll question, so you're excused from participating. I'll share the results. Everyone has them. And, that's not surprising to us. You get a mixed bag. Some people are certainly concerned about, do they have enough to retire on? And even in retirement, do I have enough to live on? And then there are people, some have those concerns, and some also have the additional concern, or more entirely a concern, of how can I afford the cost of long-term care should it be needed, and how do I preserve what I've earned, or we as a married couple in that case have worked our whole lives to save and not have it spent on the cost of long-term care. I'm not surprised no one picked providing an inheritance for their children, and I'm only moderately surprised no one said estate taxes. I guess if I asked this question 5 or 10 years ago, we would have had as many people say estate taxes as any of the other questions, or answers, I should say. But that has clearly, that ship has largely sailed. Okay, so before we get into the substance, a couple slides. And most of the people, I know there are a few people who signed up fairly late. Most people, I hope, got the slide presentation. If you didn't get it, shoot either Megan or I an email and we'll make sure you get it. There's a slide just talking about our respective credentials and experiences and so on and so forth. I am a certified elder law attorney. That I got that certification about 3 years ago after a very extensive and grueling examination and process that I had to pass. So it's something I'm happy to have. And Megan has a lot of wonderful credentials as well, and has won some nice awards. Outstanding lawyer from the Women's Bar Association. She's our outstanding woman lawyer, among a few others, but one of them. And we're very happy she's a member of our team. We have something in the chat here. Someone asked the question. But what is the email? Yeah, Megan just posted it. Thank you. Yeah. So the first question is, or the first issue is regarding Medicaid, which is largely a middle class problem. And the reason for that is that estate tax exemptions are at an all-time high or all-time highs. New York's exemption per individual is 5.85 million, and every year it goes up by an inflation factor. Compare that to prior to April of 2014, it was $1 million per person exemption. So if someone had a $2.5 million estate, their kids would be paying a fairly substantial estate tax bill in New York going back to 2014. Now it's up to almost $6 million. The federal level is almost double that, $11.58 million. So as you would surmise, very few Americans have real estate tax concerns. But that is not the same for Medicaid or nursing homes. The average nursing home cost in New York State is $12,850. And that's somewhat on the low side. And that's per month, pursuant to the New York State Department of Health. So we want to find out how to pay for long-term care. There are 3 primary ways: paying out of pocket, which is most people's least favorite way of doing it; having long-term care insurance, which probably fewer than 5% of the population has, in fact, quite a bit less than 5%. It's expensive to keep it, and it's hard to get. By the time people really consider long-term care insurance, typically in their 60s, it may be out of the affordability range, because the older you are, the more expensive it is. And the underwriting criteria are so strict that, if you have the sniffles, essentially, they're going to say you can't qualify. And then the most common way is through Medicaid. So before I turn it to Megan, I'm going to ask another poll question. I see launch a new poll, I should say. Let me find how to do this. Okay, sorry about that. Oh, I have to remember how to get to the new poll. What's going on here? Sorry, folks. End poll, and I have to end it. That's why. Now I can share the next poll. I'm still learning the polling part of this. Okay, the next question is a simple true-false question. Medicare covers most costs for long-term care. True or false? Again, everyone is anonymous. So I have to launch it, I forget. Now you can answer, folks. Oh boy, we have a very astute crowd, and the question may have been a little oversimplistic. I don't know. So I'll end the polling because everyone answered. Everyone got it right. Hooray for you. Medicare doesn't cover most costs for long-term care. Most people, thankfully, seem aware of that, and you certainly all did. So as we talk about now, there are other ways you're going to have to cover your costs of care. So I'll share that result too, and shut that down, and then we'll move ahead. So Megan can take the next group of slides.
Right. So as you guys already know, based on the polling question, right, Medicare does not cover long-term care. Medicare is a benefit that you can qualify for once you are 65 years of age. And it's like a supplemental health insurance plan. It's not going to cover the costs of your long-term care. So Medicare is not going to cover more than 100 days of skilled care, but that doesn't mean that it would even cover the full 100 days. It depends on what your circumstances are and whether you truly need that skilled care, and if you are improving, staying status quo, or you're declining. So maybe your health really is taking the turn for the worst in this case. There's really no guarantee for what Medicare is going to cover, so it's up to the 100 days, but you're not promised that amount. And some of it has to do with how you are classified when you enter the hospital for the care. It's very particular. It has to be certain classification status. You have to be there for a certain period of time. So it's important that if you are entering the hospital and you're thinking that you may need some care, whether it's rehab or you're facing long-term care, you begin to consult with some professionals to make sure that you are classified correctly to maximize the Medicare coverage. Medicare will cover the first 20 days of your skilled care, your hospital care, rehab in full. But if you are needing that care for longer than the first 20 days, even if they classify you correctly and you're receiving Medicare coverage, the remaining 80 days, Medicare will only cover a portion, and then you will be required to pay a copay for a portion of your care. And like I said, you being a resident of the rehab facility, Medicare can be cut off at any time. Again, it depends on if you still require the skilled care and making sure that you are not declining or anything like that. So there's really no guarantee that you're going to get the full 100 days or even the full 20. But if you do get the first 20 days would be covered in full for Medicare. If your Medicare coverage is being cut off, you as the resident receiving the treatment, or if you have someone who's taking care of the paperwork for you because you can't do it yourself, they're going to be considered the responsible party. And in either case, someone should receive notice that Medicare is not going to continue to pay for the care that you're receiving. And that letter, that notice will come with instructions on how to appeal that decision. And we have had people appeal it and get a few extra days out of Medicare for the coverage and things of that nature. So if you are facing this, certainly, like I said, consult with a professional to make sure that Medicare is covering as much as possible.
And as a general rule, to have any Medicare coverage in a skilled nursing facility, you have to have a 3-day minimum admission to a hospital prior to your admission to the nursing home. There is now a temporary suspension of that requirement because of the COVID crisis going back to March. I'm actually having an argument with Valley View right now because they don't seem aware of that waiver, and they're claiming the admitted resident has to have been exposed or been suffering from COVID to qualify under that waiver, and the rules don't require any COVID-related illness in order to be able to go off the street or from your home and get Medicare coverage to start. So we'll see how that plays
out. So I think we have some questions too before we get too far, both in the chat box and in the question and answer. So my reference to consulting with a professional, certainly an elder care attorney is a safe bet for a professional. But if you do have questions and you are talking with a caseworker at the hospital or the rehab facility, it's worth always asking to make sure that they're handing you the right paperwork or that there's nothing further that can be done to extend the Medicare coverage. So always ask. The worst that they can do is tell you no, and then you need to consult with an attorney at that point. And how do you find one in your area? Well, it just so happens that we here do practice in elder law. We are both attorneys, so we can certainly assist you. And then if you are not in the Hudson Valley, we can probably point you in the right direction as well. So feel free to email us about that one.
Right. And there are a few sources. There's the National Elder Law Foundation group of CELA attorneys like myself. So those are people who passed the national examination. You can go on the NELF, it's nelf.org. We also are affiliated with the National Academy of Elder Law Attorneys, NALA. In fact, I have my renewal notice right here for my dues. They charge $1,425 a year to be a member of this organization, but it's a good organization. Yes, so if someone wants, I will put those in the chat. So if people are not local, and we may have people who are not local, there's nelf.org. I'm putting that in the chat. There's, I said nala.org. And the last one is Elder Council, which is another group that we belong to that has thousands of attorneys, a couple of thousand around the country who practice in elder law. So between these various groups, you will absolutely be able to find, if you're not local to our area, a qualified elder law attorney. And if you want to vet someone, we can certainly assist in making sure the person you're talking to is someone who can really do this kind of work, because not everyone can.
And then one more question in the question and answer box is, what is the Medicare copay amount? I think for skilled nursing, it's somewhere around $165.
Yeah, I think it may be 170 now. I forget the exact number. It's close to that. Yes.
Yeah. So
that's per day.
Right.
Awesome. Thank you. Great questions, folks.
Yeah, those were good. So now we're going to talk about Medicaid generally. So different than Medicare, right? An important distinction, because we said Medicare doesn't pay for your long-term care, but Medicaid would. Medicaid is a joint federal state medical assistance program. So it's coming from both the federal government and the state government, which is why there's some variation in the eligibility rules and things like that from state to state, or some of the planning strategies and tools that we can use. It is a payer of last resort. And so it's like any government benefit. You don't want to have to use the government funds unless you really need to. So it is a means tested program, and it would pay for nursing home care. So that's what we're considering institutional medical care. But even community medical care. So this is if you need care at home or in an assisted living facility or something similar to that. So Medicaid is what would pay for this care. And like I said, you have to meet certain criteria before you can actually begin receiving Medicaid paying for your care, because it is a government benefit.
Yep. So what are our residency and citizenship rules?
Yeah, so you have to be a legal resident of the United States, which is obviously being a citizen of the United States. But I think you can also be a resident alien, right? A qualified resident alien as well.
Megan, can I just interject? Someone just posted in the chat that they lost the audio. Can other people hear us? If you can either raise your hands, that would be helpful.
Okay, I'm seeing responses there.
Yes, they can hear. So it's just that one person. Thank you. So you may have to reboot, re-enter the webinar or something. So sorry for the interruption.
Okay.
Go ahead.
So you have to be a legal resident of the United States to receive this benefit at the time that you're submitting your application. And you also have to be a resident of the state and the county where you're applying. So if I'm an Orange County resident and then my family wants to put me in an Albany nursing home, I would still have to submit my application with Orange County because I'm an Orange County resident before I entered. And sometimes that gets a little bit tricky for people who their family is trying to move them closer to them and things like that. Right, and so you have to apply in the county of your original residence if you're being placed in a home in a different county.
And we've had this happen quite a bit where, the parents will live on Long Island, for example, and the children live up here in Orange County. And as the parent declines, the child wants them closer. So they take them from their home in Massapequa and bring them up to Valley View and Goshen, for example. Even though they are in Goshen and applying for Medicaid from Valley View, the application has to be filed back in Long Island in Nassau County or something. I think it's in Nassau, and vice versa. So that's just one thing you have to know. We have to know. You may not. So let's talk about some of the Medicaid income and resource levels in place. So I'll cover some of this. So, okay, so now I'm going to launch one of my famous poll questions here. So here we go. Simple, true, false. Again, anonymous. If you have too much monthly income, you are ineligible for Medicaid in New York. True or false? And let me launch that. People are hitting the quick on the trigger finger here, and that's good. So we got a few more voters hanging out there, it looks like. People pondering their answers or electing not to vote. We'll give a few more, give another 15 seconds here. Okay, another 5 more seconds. And then we'll end the poll. So, okay, so we're going to end that poll. So this one is actually false. And this is one that gets most people who aren't versed in this area. People understandably believe that if you have too much in the way of income, you cannot qualify for Medicaid. Some states that may be true, those are what are called income cap states. New York is not one of those. We are not an income cap state, and we're going to talk about in a few minutes how you can still qualify for Medicaid even if you exceed the income limits. So interesting question, right? So we shot that down. So what are some of the rules here? Well, first, before we talk about income, what are you allowed to keep in the way of resources and qualify for Medicaid? And New York actually has the highest resource allowance in the country. Not a big number, but it is what it is. You can have in your name countable resources of up to $15,750 in a bank account or stock or anything. And there are a few others you get to keep. You have one vehicle in your name. You can also own your home in your name, and they won't count that. You can qualify for Medicaid if you meet that criteria. Most people, not everyone, of course, have more than $15,750 of countable resources. So part of what we're going to talk about in the next few minutes are how to plan to get eligible. What are the income limits? Well, if you're in your home, you are allowed to get Medicaid services, and you're allowed to keep your first $895 of income, whether that's Social Security, pension, or some combination of all those things. Interest income, dividends. So, of course, most people have Social Security in excess of this amount right away. If you are in an assisted living program, and there are a number of assisted living facilities in our area that participate in the Medicaid assisted living program. There's Braemar in Middletown. There's South Winds in Middletown. No, it used to be South Winds. Now it's called Promenade. Tuxedo, and Mount Alverno in Warwick. Those are the ones I'm most aware of. I think there's one new one too. So those, if you are in one of those facilities, your income allowance as a single person could be up to $1,477 a month. If you're in a nursing home, you're only allowed to keep $50 a month of your income, plus enough to cover your Medicare and Medicaid and even supplemental premiums. So, and in fact, I was working with a couple today dealing with the woman's mother who's over in the nursing home, and the mother has United Healthcare supplement through AARP. I think it was $220 a month, and she's going to actually be able to spend that amount of her income before having to contribute income towards the nursing home, because the government wants people to keep their private insurance for health reasons. We also have issues regarding our spouses. So while the spouse applying for long-term care can only have countable resources of $15,750, in New York, the community spouse is allowed to keep assets of up to $128,640. That doesn't include the home, which is exempt already. It also doesn't include another vehicle. So, there's some wiggle room with all this. So that's the resource allowance. As we'll talk about momentarily, you can still exceed those numbers too under a unique New York rule. How about the income that the community spouse is allowed to keep? Here we have what's called the MIMNA, which I think stands for Minimum Monthly Maintenance Needs Allowance, is $3,216 a month of income. So if you're the community spouse and your other spouse needs long-term care in the home, in a nursing home, or in your own home, you can keep up to $3,216. If your own personal income is at or above that amount, then, so let me get my little pointer thing going here. So if you're at or about this, above this amount with your own income, that's all you get to keep. However, let's say you're the community spouse, you're the wife, and the husband needs nursing home care. Your income is $2,000 and your spouse's income is $3,000. Well, your income is below the 3216. So when the Department of Social Services does their budgeting on the approval form, they will allocate to the community spouse, the wife in my example, $1,216, so that her total income equals $3,216. The balance of the husband's income will, after his personal needs allowance, be allocated towards the cost of his long-term care. If the wife is home and has $4,000 of income, she gets none of her husband's income. So if we have a couple, one with high income and one with low income, and only one needs the nursing home, we hope it's the one with low income. Or actually the one with high income, so we get the budget more to the community spouse. Otherwise, it gets wasted. So that income rule is a very important concept.
Before you get too far ahead, I know
Okay,
there
so
were
questions?
some questions. Yeah.
Good.
A couple of them you answered already. So the community spouse is the person who is the spouse that's staying home or doesn't need the care in this example. There was a question, I know we referenced being able to own your home and it not counting towards the resource or the asset limit. So I think someone had a question about how that works. And so there's sort of a caveat with the home. It's not going to count towards your $15,750 being your primary residence as long as you or you have a spouse living in the home. If no one's living in the home, let's say you're the only resident of the home and you go into a nursing home, presumably you're probably not going to return to your house. At that point, it's not going to count towards your $15,750, but there is the potential that Department of Social Services will place a lien against the home for the amount of coverage that they are paying for your long-term care. So it doesn't count towards your $15,750, but there is sort of a caveat to that. So I know that was one of the questions. And then I think we covered most of the rest. One is that does Social Security payments count as ordinary income? So yes, that's going to count as income when they're calculating how much income you're allowed to keep versus how much is getting paid over towards the cost of your care.
Okay, good, thank you.
I think we got everyone there.
You think there's a question, what is a community spouse as opposed to a general spouse? I've never heard the term general spouse in the Medicaid context. There's either the institutionalized spouse or the community spouse. That's it, unless they're both institutionalized spouses. And if they're both community spouses, we're not dealing with Medicaid, so it's not an issue. Okay, so let's move ahead here. So Megan, why don't you talk about spousal refusal?
Sure. So spousal refusal is a benefit that we have here in New York. There are a few other states that have some version of this, but not to the extent that we have here. And it's really a very nice benefit that allows those individuals who are married with only one spouse needing the care, the other spouse being well enough that they can stay in the community, to be able to preserve most, if not all, in most cases, all of their assets. So very simply, spousal refusal is just a signed statement from the community spouse stating that that community spouse, although they are above the resource limits and the income limits that we saw on the previous slide, even though they're above that amount, they do not want to contribute those amounts to the institutionalized spouse's care. So what that allows us to do is preserve the assets that are in the community spouse's name. And I think in just a few slides from now, you'll see that a strategy to preserving these assets is to transfer the assets from the institutionalized spouse's name or the person needing the Medicaid into the well spouse's name, the community spouse, and then the community spouse submits that spousal refusal, and that allows them to preserve all of the assets and the excess income. So like I said, the community spouse may retain amounts in excess of the income and asset restrictions that we saw just a few slides ago. And by submitting the spousal refusal, even though the well spouse is above those limits, the spouse that needs the Medicaid still remains eligible for Medicaid because the assets that are in that spouse's name would be below the 15,750. So we have some information here that Department of Social Services may request a contribution of 25% of the community spouse's income in excess of the MIMNA, so the numbers that we had seen on the previous slide. And whether or not Social Services will submit this request of an additional contribution really is depending on what county you live in. They have the right to request the contribution anywhere in New York State. It shouldn't matter, but we find that Social Services rarely requests it for certain counties, Orange County in particular. We rarely ever receive this request. So some of the counties that are north of us, it is just a matter of course that the applicant will, or the spouse will receive this request for the 25% contribution. And I do believe certainly south of us as well, these requests do come quite frequently. But here I think Social Services just isn't sending the requests because they're so bogged down, which isn't to say that's not true for other counties, but it's less frequent.
And one thing to note about this, keep in mind what we're really saying here. This request is only request because they can sue, as we'll get to in a second, is only for what the spouse earns, the community spouse earns and above the MIMNA level of $32.16. So if the community spouse has $4,216 a month of their own income, all that's at risk for contribution is 25% of that $1,000 or $250. So essentially they keep $4,000 and have to kick in $250 a month for their spouse's care, and then they'll be left alone. And that's not a bad deal in most cases.
Right. But as Rich just referenced, Social Services does retain the right to file a lawsuit for additional contributions as well. Again, we don't see this frequently here, but in other counties and areas of the state, it is pretty common.
Yep.
We do have a question about spousal refusal,
Yeah.
which is, are only assets that are solely in the community spouse's name exempt, so not jointly owned assets? And the answer is yes. So the spouse is saying the assets that are in my name are exempt. Jointly owned assets are going to count towards the applicant's 15,750. So that's why they wouldn't be exempt. They can't have the applicant's name on the asset anywhere.
Right. And we'll talk a bit, as Megan alluded to, about changing some of that. You know,
Right.
getting you off that asset if you're the one applying for Medicaid.
Right.
So what are some of the advantages of spousal refusal?
Yeah, so some of the advantages, aside from being able to preserve a lot of the assets or all of the assets, there's the possibility that the community spouse may not get sued. And why that's good news, like I said, is that it allows us to preserve the assets. And in many of the counties, we don't see these lawsuits coming through, which means that it's a full windfall for the community spouse and the couple as a whole, in the sense that we were able to preserve everything simply by moving it to the community spouse's name and then filing that spousal refusal with the application. And at that point, no suit comes through, everything is preserved at that time. Medicaid reimbursement rates. So if they are suing you and they're looking to be reimbursed, Medicaid only pays a percentage of what the private pay rate is for the care. So they get a discount essentially for being the government paying for the care. So as an example, these are not real numbers, but if nursing home care costs on average $12,000 per month, Medicaid may only be paying $7,000 or $8,000 per month. So if you as a community spouse do get sued, or you're expected to pay some funds over towards the cost that Medicaid has paid for the long-term care, then it is a benefit in that Medicaid would have paid less than you would have paid if you were privately paying, and you would only be expected to reimburse Medicaid for what they put out. So you're actually getting the coverage, even if you had to pay Medicaid back, at a discounted rate as well. And then on top of that, social services usually will settle for less than the full amount paid by Medicaid even. So you're getting an even steeper discount, even if you were made to pay at some point down the road. So spousal refusal is almost a default, even in the places that there is the potential that you would receive that request or you would get sued. I know being sued is very scary, but if it means that you get a discount when ultimately you do have to pay for the care, it's well worth it.
Yep.
So now we're going to talk about some transfers of assets and how those have to do with Medicaid and certainly the penalty periods. So the hard and fast rule is if you make non-exempt transfers within 60 months of applying for nursing home Medicaid or institutional Medicaid, or within, this is the new rule, within 30 months of applying for community Medicaid, including to the assisted living programs, a penalty period would be imposed for those non-exempt transfers. And during that penalty period, you would simply just not receive Medicaid paying for your long-term care. So if you've made non-exempt transfers within the prior 30 or 60 months, depending on the kind of care you need, Department of Social Services will tally up all of those non-exempt transfers and then do a calculation to determine a penalty period during which you're eligible technically for Medicaid, but they are going to refuse to pay for your care and you're going to have to pay for it yourself during that penalty period.
So I'm sorry, yeah. So we have a few issues surrounding the transfer of assets. We have the question of what are exempt assets and exempt transfers so that if you do make a transfer, it doesn't count and create a penalty. Some of those would include prepaid funeral arrangements. You can go to a funeral home at any point and prepay your funeral. And certainly when you're applying for Medicaid, that's always rule number one. Prepay your funeral. You're going to have to pay for it someday. No escaping that. Might as well pay it now than when you're totally impoverished, if that were the case. Spousal transfers are exempt. Transfers to sole benefit or can be a sole benefit supplemental needs trust. And then we have the look back period issues. 60 months prior to application for nursing home Medicaid is the famous look back period. We're going to get more into that. And now, as Megan said, there's a new 30-month look back period for community Medicaid that is not currently in effect. It'll be in effect sometime between January 1st and August or April 1st of next year, probably pushing more to April 1st. We'll discuss how all that works. And then we have the question of our penalty period, which is a penalty assessed for non-exempt assets. And there's a formula that is used to determine what this penalty is. So I'm going to bust out another of my famous polls at this point. True or false, I can give all my assets to my spouse and qualify for nursing home Medicaid the month after the asset transfers are made. Is that true or false? And we're seeing answers on both sides of the ledger. Okay, we got most people have made their minds. We still got a few people thinking about it. I'll give you another 15 or 20 seconds on that. Okay, we'll give another few seconds and then we'll end the poll. So here we were split. 7 said true, 9 said false. The answer to this one is true. You can move all your assets to your spouse's name and be eligible for nursing home Medicaid the month after you make those asset transfers. And that's a very powerful ability, or ace in our hole, as it might be, to be able to do this if there has been no pre-planning done. The key is you have to be married at that time. All right, and not everyone is married, of course. So, so from there, we're going to talk about what transfers are exempt, will not cause you to have to account for the gifts or transfers that you've made for Medicaid purposes. First, this summarizes or reinforces our true-false question. Any amount of resources may be transferred between spouses without the imposition of a penalty period. That's the biggest and most common exemption. However, if the spouse in the community transfers assets either to their children or a trust for themselves before the institutionalized spouse has been approved for Medicaid, the transfers by the non-applicant spouse will result in a penalty for the institutional spouse. And we've seen this kind of problem arise. People think, okay, it's all in my name, I can give the assets. My husband, he's in the nursing home, it won't bother his application. That is not the case. However, once the institutional spouse has been approved for Medicaid, then 30 days or more after that approval has been in place, the community spouse is permitted to transfer assets to the children, a trust, or any other third parties without affecting the current or future Medicaid application of the applicant spouse. Once you're approved for Medicaid, what your spouse does with his or her assets doesn't matter anymore, okay? It will impact on the community spouse's Medicaid eligibility, subject to the 5-year look back and the 30-month look back, but there's no impact on the spouse who's already been approved. So there's a lot of very little wrinkles that go on in these contexts here. Another opportunity for exempt transfers are to a supplemental needs trust for a child or grandchild who is under the age of 65, who is disabled. Any transfer of that type will not create a Medicaid penalty for the parent or grandparent who is making that kind of a transfer. Now, one thing you should note, though, is that when that child or grandchild, who themselves presumably is on public benefits for Medicaid, ultimately passes away, the state will get a repayment of those assets, which is not usually the case for what is considered a third-party trust, a trust created by a parent or grandparent for the benefit of a child. That usually is exempt from Medicaid even for the grandchild or child who's receiving the benefit when they die. But when the transfer is made by a person who themselves is applying for Medicaid, there's an exception to that exception, basically. But it does help defer any spend down, and the money in the supplemental needs trust can be used for the benefit of that disabled child or grandchild. So why don't we talk about some of the home rules?
Yeah. So a home can be transferred, and I know we already started talking about some of the home rules. So if we are concerned about preserving the house and avoiding the lien being placed on the house, right, then we're going to consider transferring the house. And a home can be transferred without penalty to certain individuals. Certainly a spouse, so that just falls into that regular spousal transfer exception category that applies to the house as well. There's also, if you're transferring the house to a child under the age of 21, that falls into an exception. A blind or a disabled child of any age, so they don't have to be under 21, they just have to be blind or disabled. Then there's no penalty incurred for that transfer. A sibling with an equity interest who has lived in the home for at least 1 year. So you'd have to be able to establish that, showing that they've been a resident of that home for at least a year and they have an equity interest in the house And if that's the case, then you could transfer to a sibling. And then the last exception is to what's considered a caretaker child. So presumably, and this does happen sometimes, is that you have an adult child living with you who's helping you out to kind of push off the need for additional care, right? So a caretaker child who has lived in the parent's home for at least 2 years. And again, you're going to have to be able to establish that they've been in the house for at least 2 years. But if that's the case, then that's a perfectly plausible exception to the transfer rule for the home only. That's an important distinction.
And this one, the reason for this caretaker or caregiver child exception is a public policy decision that the government has made that says if a child who has lived in that parent's home for at least 2 years has provided some level of assistance, sometimes it's a lot, sometimes it's barely a little, right? But regardless, it's not a qualitative judgment. The government assumes that that has helped keep the parent out of the nursing home for longer than they would have otherwise. So the public policy reward, is to allow that child to receive the home. Now, it doesn't solve other issues. If there are multiple children, it can only go in the name of the child who is the caregiver. And then the family has to often work out the logistics of how that house may be split among the siblings when mom or dad dies. But that can all be done if the family is reasonably cooperative. So what are some of the other exceptions to our transfer penalty rules?
Right. So sometimes people say, well, can I pay for something? Can I, buy something? Of course you can. So if a person is selling an asset for fair market value and you're receiving money in return, then that's fine. It really does have to be fair market value. So if you're selling it for less than that, then there is a portion of that transfer that's considered a gift. And certainly vice versa. If you're paying cash for an item, then that's okay as well. So you are permitted to sell an asset for fair market value if you were looking to liquidate it, or certainly if you wanted to, say, sell your house to your children. Maybe that's not the best strategy, but if that's what happened within the look back period, then they're not going to count that as a gift or a non-exempt transfer. But certainly they're going to count the amount that you've received for that sale towards your $15,750. Assets that have been transferred exclusively for a purpose other than to qualify for Medicaid. So maybe you have a history around the holidays every year of making small gifts to all of your family members, or there's some other purpose that you can establish. You would have to be able to show it to social services because they will flag that transfer. But if we can show them that maybe you have this pattern of making the gift and it's not in anticipation of qualifying for Medicaid, then it would be an exempt transfer at that time. It's definitely something that is tricky, and you don't want to have to be in a position where you need to prove that, but it certainly comes up often. And so it's not something that can't be done, but you just have to be able to show that you had some other goal in mind other than just getting the money out of your name because you knew you would need to qualify for Medicaid.
A common example where this kicks in a lot is, you have mom, the widow's got a fair amount of resources, and one of the kids is going through a very bad divorce and maybe lost their job. So mom, who's 79 years old, is helping, hires, pays for their divorce attorney and helps them with living expenses. Even if she's in so help, she's certainly not contemplating at that moment that she's given the money as a way to shelter her from Medicaid. Those cases, if you can prove all those things that I just said, even if it goes to a fair hearing, you will likely prevail, and that amount you paid for your kid's attorney and for their living expenses will not be counted as penalized transfer. So this exception is a fairly big one. It takes you often a while to get there and you have to go through a hearing, but you can save a lot of assets if you have nothing else to hang your hat on.
Right. And if you can demonstrate that the penalty, the imposition of the penalty even for a non-exempt transfer, would cause undue hardship, then they may waive that penalty for that non-exempt transfer. So technically, it would be something that you would normally incur a penalty for the transfer. If you can show that it would cause undue hardship, then they will waive the penalty period.
Sorry, I had something kicked in. Okay, so let me move ahead here. Let's talk about some of the non-exempt transfers. So we've already covered what things you can transfer without having a penalty imposed. Now we're going to deal with things that are going to create some form of Medicaid penalty.
Right. So again, all of this is a dance around the look back periods, right? This is what we're taking into consideration at the time you're applying for Medicaid to pay for you or your loved one's care. We're saying what happened within the last 30 months if you're applying for community Medicaid, so in-home or assisted living, or if you're anticipating nursing home care, what happened within the last 60 months? What transfers have been made, and do they fall into an exception or not? Now, this look back period is going to apply to both outright transfers to individuals, gifts to kids, or whoever you gave it to, but also it would apply to transfers to most trusts. So that's why sometimes when people are talking about doing estate planning, they want to make sure that they get it done early on so that they are not doing their estate planning within that 30-month or 60-month look back period, because those would be non-exempt transfers as well. So these periods are kind of a snapshot. When we're submitting these applications, or you're submitting the application, you're going to also have to give a snapshot of your financial information for the previous 30 months or 60 months, depending on the kind of Medicaid that you are trying to qualify for. So it's really just a snapshot of the assets during that time.
Okay, so before we move on, we have poll number 5, or question number 5. So this question is another true false. If I give away any amount of assets to my kids during the look back period, Medicaid will not cover my long-term care costs for 5 years. True or false?
Did you launch it? Because I don't see it yet, but
I did. Other people are answering it. I don't know why you're not getting it.
This is the one I think I never see.
I don't know what that's all about. So, all right, I've got 14 of people to have voted. I'll give you another 10 seconds or so. And then we'll end our poll. Okay, we'll end the poll. So 13 out of 14 came away with the correct answer. You may be disqualified for 5 years, but there is not an automatic disqualification if you make any amount of gifts during the 5-year look back period. It's a mathematical equation, calculation that we'll get to momentarily, that determines how long a Medicaid penalty period will result from a transfer of non-exempt assets during the look back period. Okay, so we'll share those results. Let's move ahead to the penalty period calculation. So Megan, go for it.
Sure. So our major concern with making these transfers and whether they're exempt or non-exempt transfers is what happens if it's a non-exempt transfer. And like we said, all that you don't get taken away to jail or anything like that. All that happens is a penalty period is calculated, during which time you are technically eligible for Medicaid because your resources are now at or below the $15,750, but Department of Social Services creates the penalty period or calculates it and says, we refuse to pay for your care. Medicaid will not pay for the care for this period of time. So what they do is tally up all of the uncompensated, meaning you didn't get something in return, non-exempt transfers, meaning it doesn't fall within one of those exceptions that we talked about, made during the look back period, whichever look back applies to you, the 30-month or the 60-month. And then the total value of the transfers is divided by the average monthly cost of nursing home care, which is called the regional rate, as determined by New York State in the year the application is filed. So this regional rate changes a little bit every year, but that's the divisor for figuring out what the penalty period. And by dividing the total value of your transfers by the regional rate, they'll come up with a set number of months that they will refuse to pay for the care, even though you are eligible for Medicaid and you are actively receiving that care, whether it's nursing home care or in the home, what have you. So I think we get to see in a minute the regional rates here for the different regions within New York. So you can see each region has its own regional rate. And again, this number changes a little bit every year. We here are in the Northern Metropolitan region, which is $12,805 per month. That's the monthly rate. And then that's how they figure out how many months of care that you will not have coverage for. So if you made $100,000 worth of transfers within the 30 or 60 months that you need the care, and then they divide that by the 12,805, that brings you to about a 7.8 month penalty period. So you've submitted your application saying that you are at or below the 15,750, but they've picked up on $100,000 of non-exempt transfers. So now you have just about no money to your name. You need the care, but you have a 7.8 month penalty period that Medicaid will not pay for your care. You're going to have to figure out how to otherwise pay for that care. So the penalty period begins to run on the date that you file your Medicaid application, provided that you're otherwise qualified or eligible. So provided that you do meet all of the other criteria below the 15,750. So some people wonder if there's any way to get the assets out of their name, and then hopefully the penalty period begins to run, but they won't quite file the application yet. The application has to be filed for the penalty period to start ticking. There's no real way to get around that. And for community Medicaid eligibility, the applicant has to show by way of a functional assessment. So an assessment is actually done that person needs those long-term care home services before the penalty period would run. So they have to actually show that they need the care and they would otherwise be getting that care covered by Medicaid before the penalty period starts. So under the new community Medicaid look-back rules, and again, this is brand new as of this year, transfers made prior to October 1st are fully exempt of this year, October 1st, 2020, are fully exempt from the Medicaid penalty calculations. So like we keep saying, that 30-month look back is brand new. And so it's not going to apply to transfers made prior to October 1st. Now that we are beyond that date, we're keeping a close eye on how all of this is unfolding. At this point, it's still unclear when the Department of Health will begin implementing the community Medicaid penalty period. You know, every time we check in on this and see where they stand on it, it seems like it's getting pushed back a little bit further each day. So we're anticipating that it definitely wouldn't begin until at least January 1st of 2021. But as things sort of unravel, it may be pushed back even further. So I think the latest date we saw is about April 1st of 2021.
So this is going to open a whole new avenue of complexity and determinations where it's been pretty straightforward in the past. And so less and less people can really do this themselves. That's just the reality.
Right. I should clarify that, like I said, all this is brand new. And when I keep saying that, I don't think I've ever specifically said prior to this new rule, there was no look back period for community Medicaid. So the implementation of that 30 months, that's that brand new part. Before that, you could move your assets and then the following month apply and qualify for community Medicaid here in New York. So it's a major change and we're still watching how it's going to play out.
So now we're going to talk about how we can implement some planning ideas in a crisis case when we don't have exempt transfers. We don't have a community spouse who we can transfer assets to. We don't have a caregiver child who we can transfer the house to. We don't have a disabled beneficiary who we can transfer assets to. So this is where we implement loans, primarily a loan strategy, what we refer to as half a loaf plan. So we use what's called a Medicaid qualifying loan arrangement in crisis planning. Crisis need meaning mom or dad or sister or brother needs care now. So how does this work in a nutshell? So let's say a parent has a total of $180,000 of non-exempt resources. Instead of giving away the entire $180,000, what we can do is have them make a gift of $90,000 to their children, with the remaining $90,000 of non-exempt resources loaned to one or more of the children. And it's memorialized by a special kind of promissory note. That $90,000 transfer will result in a period of just about 7 months of penalty. That penalty period will now begin to run immediately because by virtue of this $180,000 complete transfer, part loan, part gift, mom now has $15,750, so the penalty period will begin to run. The loan repayments and the parent's remaining other income will be used to cover the 7-month penalty period, so that by the time the penalty period has elapsed after 7 months, Medicaid will then start paying in month 8, and the other $90,000 of gifted money will be preserved. If instead, without proper guidance, the family had transferred the entire $180,000 as a gift, the penalty period would have been not 7 months, but rather 14 months, with no money to pay it except the money, the $180,000. The family would end up with zero. Here they're ending up with $90,000. The loan must be a special kind of loan arrangement for Medicaid. There has to be an interest component, as most loans would have. Given the current applicable short-term federal rate is like less than 1%, it's peanuts, because these loans are short-term. They could be anywhere from 2 months to 30 or 40 months at probably the far end. They have to be repaid within the parent's life expectancy. And like I said, almost always that should never be an issue, because even a 90-year-old has like a 7 or 8 year life expectancy under the tables. These loans are usually going to be 1, 2, 3 years, 4 years tops. They have to be paid in equal monthly installments. Back pre-Deficit Reduction Act, this is before 2006, I used to do balloon notes. I would do, a $200,000 loan payable $100 a month for 10 years, and then a balloon after year 11. And when we're dealing with an 88-year-old parent, that's probably not big risk. Most of those assets would pass to the family. Can't do that anymore. It has to be equal installments. And the loan is going to be non-cancelable upon the death of the parent, which is really not a real problem, because if the parent dies during the term of the note, they haven't received Medicaid yet, because Medicaid doesn't start paying until after the note has elapsed, and therefore there's really no issue as far as that goes. But that's what the rules require the note to specify. And the note, and this is very important, cannot be assignable. When you take out a mortgage on your home and you sign a promissory note at the closing, those notes routinely in the past, maybe a little less today, but certainly prior to 2008, they were always sold in the secondary mortgage market. Those notes are assignable. This note cannot be assignable, because if it can be assigned or sold, then you have something of value. And if you have something of value, you're going to be disqualified for Medicaid. If it's non-assignable and all you're entitled to are the equal monthly installments from the note, it is considered an income stream and not a resource. Big theoretical and practical difference. As an alternative to a loan, and this is rarely used in our practice, some states more so, if the person doesn't have a child, except an applicant is an aunt or uncle, we get this a lot, they don't have kids, and there's a little bit of concern that the niece or nephew, for example, is maybe not going to make the note payments, because that the whole success of the strategy requires that those no payments be made. You could actually have the client purchase a short-term immediate annuity that will pay payments back in the same manner as the note. And there are certain rules about the annuity, that the Department of Social Services must be named a primary beneficiary with some exceptions. But again, this is not really a practical issue, because if the client dies while the annuity remains unpaid, they haven't received Medicaid yet anyway, so it's really not going to go to DSS at the end of the day. We also have another available trust structure for transfer of assets or income, which are called, in this case, or we're talking about income specifically, called pooled income trusts. These are used exclusively for community Medicaid purposes. We can't use them for nursing home Medicaid. But if someone in the community, remember, you probably wouldn't, but I'll refresh your memory, you're allowed to keep, if you're living in your home, $895 a month of income. Well, if you have property taxes or a mortgage or certainly rent, $895 is not going to get you very far. And so if you had, $2,895 of total monthly income and can only keep $895 of that monthly income, had to pay $2,000 to cover the cost of your care, you probably can't afford to live home anymore. So the government allows you to instead have paying towards the cost of your care with that monthly income. You can establish or fund what's called a pooled income trust, which is a special type of trust operated by nonprofit entities that allows many people to contribute to this trust, have a separate account established, and that's the next bullet point. Everyone in a pooled income trust gets a separate sub-account. And that $2,000 a month of income in my example can then be funded into that pooled income trust. And then the Medicaid recipient or their representative, your child or agent under a power of attorney, will then typically submit monthly bills or quarterly bills to the pooled income trust trustee, who can then pay those bills from the pooled income trust rather than have it go towards the cost of care. Very, very important option in these cases. Again, it's only a community Medicaid option. And again, it's in excess of your monthly income amount. And this just talks about the mechanism of having it paid. The beneficiary will submit, or the representatives, the monthly expenses. And what do those include? I mentioned a few: rent, mortgage payments, property taxes, utilities, insurance, clothing, food, travel expenses, and the like. It's important when you set up a pooled income trust, the income from the trust can only be used for the Medicaid recipient's benefit, cannot go to a spouse or a child. So if a married couple is paying $2,000 a month rent in an apartment, only $1,000 a month can be taken from the pooled income trust to be paid towards the rent, because that constitutes 1/2 of the rental obligation attributable to the Medicaid recipient. So Megan, why don't you talk about personal service contracts?
Sure. Before we move away from pooled trusts, we do have a question about them. Is it true that the pooled trust, I'm assuming you mean here, keeps all of the money if the person passes away? So the answer to that is yes. If you have funds in the pooled trust that you've contributed and then you pass away, or you end up needing nursing home care, then whatever remains in the pooled trust does not come out to your family or your beneficiaries or anything like that. It stays within the pooled trust at that time. So that's the answer there.
Right. But from a strategic standpoint, the idea is when you use a pooled income trust, you're hoping that you are going to use every month or within the year all the income that's in there for personal expenses. So it's very rare that there's much, if at all, left in a pooled income trust, unless that person has gobs of income and can never spend it all every month. That would be the only exception.
Right. So we have personal service contracts are available, and they're appropriate in an instance where there is a child that is helping their parent who needs that additional care. So maybe they're doing this for an extended period of time as their main occupation even. They've given up on their job to stay home and help mom or dad. So personal service contracts are an agreement where the parent actually agrees to pay the child compensation to provide that kind of care and assistance, and make sure that their parent is well taken care of. And this is a role that children will typically take on, although it is difficult to ask them to leave their occupation to do this full time. But it does allow the parent who is needing the care to actually pay the funds over to their child. It does have to be a written agreement for reasonable compensation. So there are some terms that have to be included in there, to make sure that the child is receiving something reasonable, not too much and not too little. And on the child's end, it really not only requires them to actually care for their parent, but keep good record keeping for the care that they're providing and payments that they're receiving. And the compensation that they're receiving does have to get paid on the books, as we say, meaning that it would be considered income to the child who is the caregiver, and that child would be required to pay income taxes on that compensation. But it's a nice tool that can be used to allow for assets to be spent on the parent's care and go directly to their child, and to memorialize that that is what the money is being used for. It's not just gifts to the child, but it's something that is documented.
Yeah. And one very important legal document, people always say, I need a will, I need a will. And yeah, everyone should have one. Most important document really is a power of attorney, durable power of attorney, for people who might have to do asset transfers or other engage in Medicaid planning. Because and it's very important that the power of attorney has gifting powers, full gifting powers. Most general powers of attorney that are out there do not have full gifting powers. Because without a gifting power of attorney, and if you need to start doing some crisis Medicaid planning, and your parent or the other person who we're talking about for the care no longer has the requisite mental capacity to sign a new power of attorney, you can't move those assets to do the half a loaf planning or any of the other stuff we've talked about. Otherwise you need court approval to get to do Medicaid planning, and that can be very, very expensive.
Mm-hmm.
They're time consuming and expensive. So as we wrap up on our last important slides, we're going to talk about the Medicaid, irrevocable Medicaid trust. Everything we've been covering so far is of a reactive crisis planning thing. And as you can see, there's a lot of stuff there. And we can still do a lot of good asset preservation, even at the last minute when someone needs care today. But it's always better to be proactive and do things earlier than later. And that's what the Medicaid Asset Protection Trust will do. So there are a couple key components of a Medicaid trust. It cannot provide the person creating the trust, who we refer to as the trust maker, any of the principal access, but it can authorize distributions of income to that person. By creating and funding an irrevocable trust now, we'll start the 5-year look-back clock running, or 30-month look-back for community Medicaid. So if you sign a Medicaid trust on November 1st, 2020, come October 31st, 2025, all the assets in the trust, no matter what they're valued now or hereafter, are exempt. We don't have to worry about transfers or spousal transfers or any of these other things. It's safe. And it almost is always a better choice than outright gifts in virtually every case we can think of. So before we show you sort of the flow of a Medicaid Asset Protection Trust, I have the final poll, which may make you happy or not, I don't know. I like these. So let's take the last question. Multiple choice. Under New York law, an irrevocable trust can be revoked either by the sole consent of the grantor, only by a court, by written agreement of the grantor and the trust beneficiaries, or it cannot be revoked because it's irrevocable. So this is a new question I came up with. I think it's sort of fun. Okay. Here we go. 2/3 or 3/4 voted so far. Okay, we'll wait another 10 seconds or so. 5, 4, 3, 2, 1. Okay, we're going to end the poll. Interesting. Most people nailed this one. So even though a trust is irrevocable under state law, as long as you have the written agreement of the grantor and the trust beneficiaries, you can terminate it. If you could do it by the sole consent of the grantor, it would be akin to a revocable trust. Wouldn't help us much. And it definitely can be revoked, even though you would think, based on its name, it's irrevocable. So very good to know, because this is very important as we now discuss the mechanics of the irrevocable trust to see why it's such a wonderful planning tool. So Megan will take us away on this.
So with the irrevocable trust, and because we didn't talk much about trusts today, I just want to make it clear that this is a diagram of the functions of the trust, but the trust itself is actually a contract. It's a contract that you as the trust maker would execute, and it would have certain terms and provisions in it. So like Rich said, we like to use the term trust maker, and we have that it is possible that there could be more than one trust maker. So you can have a joint trust, and that is typically the strategy between spouses. We'll often do a joint Medicaid trust. And the trust maker or trust makers, they're the person or people that are signing this trust into effect, and they are funding this trust with certain assets. And when I say funding, I mean that they are retitling certain assets from their names to the name of their trust. And that action is a transfer. That's why this is good proactive planning. You want to do it in advance of that 30-year or 30-month or 60-month look back period, because it would be a non-exempt transfer and incur a penalty period if you've done it within the look back period. And you can transfer just about anything into this trust, although we would not recommend you transfer everything into this trust for a few important reasons. But you can put liquid funds, investment accounts, brokerage, certainly real property can go into this trust. And it's really going to be a counseling conversation as to which assets would be the most appropriate to put into the trust and start to work on protecting those items. So like I said, as trust makers, you're going to transfer certain assets to the trust, and that transfer is subject to the 5-year or the 30-month look back period, depending on the kind of Medicaid you end up applying for. You can be your own trustee, and the trustee is just the person or people responsible for managing the trust assets. So certainly you would have the authority to make sure that the accounts that are within the trust are invested properly, or if you wanted to move them to a new institution, all within the name of the trust, you can do that. So you control how the assets are managed and any distributions that are being made. Certainly, like I said, you can be your own trustee, and if it is a joint trust, both trust makers can serve as trustees. You also reserve the right to replace any successor trustees that you would have named. So in here, while you have capacity and you can think about who you might want to succeed you if you can no longer manage the trust assets, you're going to designate those people that you do trust to serve as trustees and manage your assets if you can. But if down the road you say, you know what, that was a terrible choice, this person and I have a really strained relationship now, or they've proven to make some poor financial decisions, you absolutely can change who you have as trustee in the order of succession there. Okay, so like I said, we're going to be careful about what we're placing into this trust because we want to try to maximize the protection for the assets. So we want to get as many assets in there as reasonably possible, but we do have to be careful because you as the trust maker are permitted to receive income that's being generated from the assets within the trust. So that part doesn't change. If you have an investment account and it's generating some income or interest, right? You're allowed to receive that at any time. You as trustee can go ahead and distribute it out to yourself. But in order to receive the protection that we're shooting for, you are not permitted to receive the principal out of the trust. So you can't say, you know what, I wish I had $10,000 of principal from that investment account I put in the trust. Let me just dip in and take some. I'm the trustee, right? I can distribute it. You can't. The terms of the trust restrict you and you are not able to distribute principal out to yourself. So for this reason, we're going to be strategic about what we're placing into the trust because we don't want you to feel restricted and that you can't use your funds. So between figuring out how much income you have and what your expenses are, we determine together how much of the assets should go in the trust and how much should stay out so that you're comfortable. However, sometimes things go a little bit awry, right? Your circumstances could change. And even though the plan as we put it together is perfect on the day we put it together, maybe down the road you decide, I wish I sort of kept some of the principal out that I put into the trust. Or maybe you just want to make a small gift to someone. In your trust, you will have certain individuals that you, as the trustee, can make distributions of principal out to. So again, this function can be used if you are going to make minor distributions out to some family members. Typically, it is your family members that are listed here as your other lifetime beneficiaries of principal. But if you did decide, you know what, I wish I could get on $10,000 of trust principal, you as trustee can distribute $10,000 out to your principal beneficiaries with the sort of acknowledgement or understanding that that beneficiary would take that $10,000 and then give it back to you or purchase the item that you needed them to purchase. You could have used that money for. So we don't recommend that you're using this all the time, but it is sort of a safety mechanism where you could get some of the principal out of the trust if you needed to use it. You should only do it if you are going to be spending the principal. It doesn't make sense to take it out of the trust and put it back in your own name for it to just sit there just in case, because once it comes out of the trust and back to you, it's no longer protected. It's not working towards achieving that protection that you were shooting for when you put it into the trust initially. But there is a way to get principal out of the trust if you really, really did need to. The class of beneficiaries that are permitted to receive principal are subject to something called a power of appointment, and that's the power to change who those beneficiaries are. This is a power reserved by you as the trust maker. So if someone doesn't play ball, you distribute funds to them and then they decide not to give it back to you the way they agreed, which they are allowed to do, you can then use your power and cross them off the list of people who can receive principal from your trust. Also, if you needed to collapse this trust, maybe circumstances have changed drastically and suddenly you need long-term care, but you didn't make it through your 30 or 60-month look back. If you needed to collapse the trust, as Rich showed you in the poll, you would need the signatures of your beneficiaries. And that is a lot easier administratively if you really only have one or so beneficiaries. So what you could also use this power for is reducing the number of your lifetime principal beneficiaries down to one who's willing to sign off on the documents so that you can collapse the trust and maybe do some crisis planning to protect your assets instead. Like I said, a house is typically a good asset to go ahead and put into your trust. It's usually a big sum of equity. So if you do put your house in here, you still get to keep your capital gains tax exemption if you decide to sell that primary residence. So in case you're not aware, for your primary residence, you do get a capital gains tax exemption of up to $250,000 of gain for an individual, double that for spouses. And that really reduces or completely wipes out the capital gains tax that you would incur on any gain accumulated in your primary residence. Even though the house is being redeeded to the trust, you don't lose that benefit. You get to preserve it. And while I'm on that, if you put your house in the trust and you decide you want to move or you want to downsize, you as trustees are permitted to sell that house and purchase your new house. The proceeds would be made payable to the trust, and then the trust can go ahead and purchase your new house without ever restarting that look back clock that we worked on. Okay, so let's say you put this trust together. Maybe you do or don't end up needing it to protect your assets. Maybe you never need long-term care, but unfortunately, most people do need long-term care. After you, or if it's a joint trust, you and your spouse pass away, the trust functions a lot like a will in the sense that it dictates, based on what you have cultivated it to say, it dictates where your assets go after you've passed away. So if you want your assets split equally between your two children, then the trust terms will take the place of a will in many instances for the assets that are within that trust. It will make sure that those are divided and distributed to your children in the manner that you've described. Now, when I say the trust makes sure, the trust terms mandate that that is what happens, but your successor trustees and the professionals that they're working with are the ones who make sure that it actually happens, and they have to follow the terms of the trust. So the trust directs where the assets are going to go after you've passed away. In this diagram, we have included protective trusts for each of the beneficiaries, here children. We, when we're doing our planning, are huge advocates for using these trusts. What they do is they allow sub-trusts, like little Russian nesting dolls in your trust, sub-trusts to be set up for your beneficiaries, because these sub-trusts are even better than the trust that you had for yourself. They protect the assets for the beneficiary. If they ever encounter a creditor issue, the creditor can't take the inherited assets out of the trust. If they get divorced, the divorcing spouse can't take half of the assets that are in the trust for the beneficiary. If they have some kind of catastrophic illness and need to qualify for government benefits, then their trust can be converted to a supplemental needs trust, which allows them to receive the benefits, continue to receive it, and the inheritance doesn't disqualify them for that. And then to the extent that you would want it, certainly you can include some bloodline protection. So you can say, if my child passes away, I want that money to stay in the bloodline for my grandkids, not pop out to in-laws. So we do have some sub-trusts depicted here, very flexible. You can make the beneficiary their own trustee. It's really absolutely the way to go. And we can certainly talk more in depth about that in another webinar or during a meeting. And the last thing I'll just point out here is another place where you reserve a power of appointment and you can grant powers of appointment. So certainly if you change your mind about who your beneficiaries should be after you've passed away, you can cross them off the list, right? You can change your beneficiaries. So if you have a falling out with someone or you want to add someone additional, you can change your after death beneficiaries here, and you can set up trust structures for those individuals as well. You can also give a power of appointment to each of your beneficiaries. So if you're not too concerned about bloodline protection, like I talked about a few moments ago, then you can give them the opportunity to leave the funds to their spouse if that makes sense to them. But you essentially give them the keys to the castle after you pass away if you want, but you don't have to do that. So this irrevocable trust has a lot of lifetime benefit and function. It's really the way to go when we're talking about preserving assets for long-term care. If you know enough to do it far enough in advance before you need that care. So like I said, this is the proactive planning, and this is absolutely the strategy of choice. We do so many of these. It's like the Swiss Army knife of trusts. It does absolutely everything you need it to do. You know, like I said, we're doing it in, I would say, at least 75% of the planning. But certainly, if you end up needing care sooner, then all of the crisis strategies that we talked about earlier today would be available to you to protect assets as well.
That is a good summary. So we're now sort of at the end, and we do offer for those people who are interested in following up from our program today, if you make a consultation with myself or Megan within 20 days, we'll give you a free copy of my book, Secure Your Legacy. And we do ask that you take a moment to provide the seminar evaluation form. I think I have the copy of it here. I do. And so the form is fillable. Those folks who registered in advance would have gotten an email, and you can complete that and email it back to us. If you do wish to have a follow-up meeting, you can do so by indicating, please contact me, and we'll do that. Now, only if you do that. And ordinarily, Megan and I would charge $400 for an initial consultation. For those people who attended the webinar today, there is no charge. One other thing that we have is we are recording the, let me shut this down. We are recording the webinar. So, I don't know, did it show up here? Let me see. Are you seeing the website here?
No, now we're seeing the last few slides.
Okay, so let me, oh, here it is. This should do it. How about now?
Yes.
Okay. On our website, you go to About, and under the workshop videos, it's not there yet, of course, because it's just being recorded now. You'll see, and these are all the other workshops and segments of workshops that are there. So we have a lot of material available for free on our website. We encourage you to check it out, and this one will be uploaded in just a couple of days. Just going back to the webinar here, that really summarizes it. I see one other thing in the chat box here, and I'll respond privately to this information. If you have any questions in the next minute or two before we log off here, by all means, let us know. You have multiple ways to reach us. Our website, you can get our email addresses on there, and we'll be happy to have a chat with you. This was a very engaged crowd for a one-way conversation. That's why we try to do the polls and the chats and the questions. Hopefully you got the information you need or are interested in, and we're happy to, again, follow up and help you in any way possible. We are inundated with Medicaid cases now, and I don't see that changing anytime soon. We wish you all the best and good, safe health. And we hope everyone has a good end of the year and a good, safe beginning to 2021. So thank you all for that. And without further ado, we'll say a good evening. Take care. Bye-bye.